So now to introduce our wonderful guest. So first, our in-house speaker is Marcy Karin, the Jack and Lovell Olender Professor who directs the UDC Legislation and Civil Rights Clinic and also chairs our Clinical Affairs Committee. And then our guest is the wonderful Marsha Griggs. She is an Associate Professor of Law at the St. Louis University School of Law and the President-elect of the Association of Academic Support Educators. She has also served on executive boards for the AALS section on academic support and the Society of American Law School Teachers. With that, I'm going to go ahead and turn the mic over to our wonderful guest so that we can all learn from them.
Thank you so much, Professor Cazares-Willingham. I am so thrilled to be having this conversation with Professor Griggs, who I met virtually in 2020 when she was engaging in advocacy to address some of the immediate concerns that rose up with administering a bar exam in the middle of a global pandemic, including articulating some alternatives for the legal community to explore. In addition to working with other faculty, Marsha was actually incredibly generous at the time when she mooted and offered some substantive and strategic feedback to my clinic students who were working on a project to help them figure out how best to ask state boards of law examiners to remove some menstruation-related barriers to the exam. So she's been very kind to clinic students, to clinics, and experiential learning over the years. Around the same time, Professor Griggs wrote an excellent Howard Law Journal piece about what an epic fail the exam administration was during the pandemic and how we collectively failed our students by plowing forward with uncertain versions of the status quo and all of its baked in racism and ableism and sexism, instead of being creative and adapting to changing times. And if you haven't read it, her 2019 article about building a better bar exam that was published in the Texas A&M Law Review was really a foundational piece for me in terms of thinking about how, if we're going to go forward with standardized exams as an entry to our profession, that there are ways that we could redesign them to do less harm in the process. Since then, as most of you know, the National Conference of Bar Examiners has put forward a new bar exam format called Next Gen. The Next Gen bar exam is scheduled to debut in July 2026, and the current uniform bar exam is going to sunset effective February 2028. As I understand it, Next Gen is going to consist of 3 parts, right? Standard multiple choice, some short answer, and a performance-based task. In terms of today's conversation, right, some of the substantive areas of laws that NCBE is testing are ones that some law school clinics, especially colleagues who teach litigation-based clinical practice, either might use or might practice in, so things like civil procedure and evidence or crim law or in 2028 family law. But Next Gen is also going to be testing skills, what they call foundational skills. And while they focus on skills relating to litigation, in my opinion, all clinics, even non-litigation clinics like mine, could have some role to play in helping students figure out how to best prepare for the topics and skills if clinicians want to or can find time for that role. And so all jurisdictions have to move to Next Gen or establish some other way to license new attorneys. And with that background, enough from me. And I just am really looking forward to talking with Marsha about all of this. Should the people that are on this webinar be excited about what this new exam has to offer? What do you think?
Well, here are my thoughts. And first, let me just say thank you so much for this wonderful invitation. It really is an honor to be invited to have this conversation. And because when it comes to the bar exam and licensure matters, I'm like a pig in mud. So there's just never a time where I'm not happy to talk about something that most lawyers and a good number of law professors would like to ignore and never think about again, which is the bar exam. But you asked if we should be excited. And so here's my answer. I hope so. I'm excited, or at least I want to be excited. If this new format of the bar exam is what the NCBE says it's going to be, then yes, it is exciting, and there is great reason for any of us in this field identified as skills teaching, we all should be excited about it. But that if is big, and it's in all caps, bold, and underlined, because no one knows, and even the test maker has admitted that we don't know yet. We don't know about timing. We don't, like, there are a lot of questions that they don't have the answer to, and they have, backtracked on many things that they've promised that will distinguish this exam from its predecessor version. So my answer again is, yeah, I want to be excited. I am excited, but that excitement comes with a huge disclaimer. You know, if so, there we go.
Yeah. I appreciate both the if and the cautious optimism I hear in your voice. And, I wonder what actually are the implications, right? There are some entering students who will be taking the exam, right, in its new version. But so, like, what are the actual implications of next gen, or those states that have actually listened to you and others and have started creating some licensing alternatives? What should faculty who are affiliated with clinics sort of be aware of or be thinking about?
So, I think, and again, this is from my perspective, only, but I think the implications for clinical faculty of this next gen format, whatever it looks like, are huge. But I would just, I'll submit to the folks who are kind enough to listen to me today to say, you know, my answer is that they're huge for clinicians, but I don't see the implications as, what things do we need to do? And of course, everyone who teaches students, and particularly, clinical faculty, we care about their competence. We want to make sure that they're ready to become attorneys. But I think this is a wonderful opportunity, not for us to adopt more invisible labor as, quote unquote, designated skills faculty, but to really take a visible role in what a competency assessment should really look like. You said this exam is going to test practice skills. Well, we're your people. You found us. We're the ones who know what that should look like. So where do we sign up? When are you going to listen to us? Because we can tell you, I've been waiting for this. So I really do think it's huge, because if this exam is what it purports to be, it has to include the input of experienced clinicians. It has to include the expertise. It has to be built considering the expertise of folks who, for a living, assess the potential practice competencies of law students.
So that sounds like an opportunity to me, right? But also, an area that could be ripe for some understandable concerns when you talk about things like invisible labor, right? What role clinics can have, and faculty that are affiliated with clinics can have in training students for the next gen. Right? So do you have any insights about sort of how next gen prepping skills development and licensing that's testing skills might further overtax sort of limited resources when people are figuring out how to comply with a whole host of new sort of ABA regulations and competing interests and demands on time and resources? Just any thoughts on what to do with that entire bucket of stuff?
Yeah. Fully understandable. And so, like I mentioned in my response to your prior question, the invisible labor that all or most of us are certainly familiar with. I would, in response to your question about, opportunities, but, cautious risk, I would urge clinicians to resist the inclination to be reactive. And I say that without judgment. I say these are our survival skills. These are the survival skills. And I'm not a clinician, but I group myself with the labeled skills faculty members. And these are the very common survival skills of any non-tenure track faculty member. Without those status protections, we tend to be reactive. Okay, what's required? What do I have to do? Is there something new that I need to know? And here I would say, despite our survival instincts, this is a time, it's an important opportunity for vocal leadership. It's an important opportunity to hear what's in the queue and to not say, okay, so I have to come to the seminar so I can learn what the new exam is, so I can see if my job description is changing, if my, if my clinical assessments will be changing. Rather than approach it that way, I would simply say, oh, I hear that this is going to be skills focused. So again, what does that mean? That there's going to be memo writing? Does that mean there's going to be client intake? What about, non-litigation things? This is the time to ask questions of people in leadership. This is a time to volunteer. And again, some of the invisible labor we can't erase, but it's, if there are going to be decisions that affect me and how I run my clinic, how I do my job, how I teach my students, then if there is a curricular decision that's associated with that at my law school, you know what? Even if I don't serve on the curriculum committee, I'll email the chair. I want to talk to them about, if we're making changes, here's what should be included. Year after year, my students are underprepared in this area. I mean, I just think this is a time to be very vocal and to share, your insights. And there are ways for folks who don't have any status protection to share those insights without being, deemed radical. But if we don't open our mouths now, this is a wonderful time to have a seat at the table. And I just want to say, those actions are important, because if we're at least included in the conversations about curricular decisions, what we're going to be reacting to will be changes that we've recommended or things that we understand, versus having someone else make decisions that affect areas that we solely work in.
Yeah, it's really helpful. And I appreciate your comment about vocal leadership and acknowledgement of different statuses that colleagues have. In your response, you shared a number of suggestions of sort of stakeholders within someone's own campus. I know that you've been very engaged beyond your own campus or campuses, as someone who recently lateraled. Are there any places where you think hearing the sort of clinical voice outside of people's home institutions could be more useful? Or, for those that haven't been engaged in the licensing alternatives in the next gen bar conversation to date, just where might they go, or where should the collective voice go? We have associations who have been very active, right? But where else might we sort of lend our perspective?
That's a wonderful question. And my direct answer to that question is everywhere. Absolutely everywhere. I would say conversations, lunchtime conversations with your fellow clinicians, conversations with your students, because it is a mistake for us to assume that our law students know what's in the queue for the bar exam. And there may be second year students in clinics that have no idea that by the time they're third years, the exam is going to be different. And, they're listening and taking the input of current third year students who are going to be taking an entirely different exam. And again, I would say formally, informally, through your organizations, through CLIA, through different formal organizations, but through informal organizations. It is, and this is, my suggestion. It is unfortunate, but also understandable, that there is a big disconnect between skills faculty, in fact, all faculty, and the licensure exam. And it's because for years, for decades, we've been saying this exam doesn't look like practice. This exam, we tell people on the bar exam, you need to know that. Or, even disconnected doctrinal faculty will say, well, I'm not going to cover that. That's what bar prep is for. It's time for all that to be put away with. So we just need to have these conversations to any listening ear. And, if your audience that you have access to is limited, they know other people, it will spread, when people are looking for speakers, or I'm so happy to be invited to this conversation with clinicians. And, I'm quote unquote an outsider. So there is always a place. The conversation that you just have over the lunch table, someone else could say, hey, I just had lunch with a person who knows about this. Why don't you incorporate this person? And I'll add kind of finally to my response to this one. I think, and I've lauded the NCBE in my writings about their willingness to reach out to faculty, to include them in drafting and in the planning for next gen. And I want to believe that they have clinical faculty members there. I absolutely do, and I'm not saying anything to suggest that they don't. But I am saying I don't know any of them. I haven't heard of any of it. So in these conversations and talking to your colleagues, maybe they'll say, "Oh yeah, I'm on the drafting committee or I'm on committee." And that's good. And let them know what you're concerned about. Let them know what's important and ask them, how's the drafting going? I don't want your confidential top secret information, but for goodness sake, are you giving input and is the exam being built around that? Or are you on a committee just listening to them say, here's what the exam is going to be, tell your friends? Like, this is important information. And if we aren't willing to take conversations and have at least a modicum of control over our professions and our sole practice areas, then there is no hope for us having any control or input in the future.
Well, I choose to, whenever possible, live in the land of hope. So what I hope we can talk about what clinicians could do to actually better prepare students for the bar exam, right? For the next gen version, from what we know about it, right? From what we anticipate, or as we think about how to share how we are already training skills, right? And our thoughts on how to, I don't know, scale that out, right, into a licensing exam. As someone who has been in different rooms than me anyway, what do you think clinicians could do to actually help our students for the next gen bar exam in terms of especially the skills component that's getting tested, but really anything that's coming in the 3 areas?
Well, so I would say first and foremost, regardless of the type of clinic, you are already, and you are the only exposure clinicians. And, I know there might be some technically non-clinical faculty teaching experiential classes, but the experiential learning aspect of legal education is the only time, the only opportunity that students have to really connect with the practice of law. So what you're doing, you're already building the skills. It's up to the examiners to create an exam that tests what you do, not vice versa. I mean, the tail has wagged the dog for too long, quite literally. And I would say what you could do differently, probably nothing in your clinics or in your classrooms, from what I'm aware of. But I would say the one thing is to look at the bar exam, to look at the questions. And for the understandable disconnect that I've already talked about, too many of us don't. We remember our bar exam. It has changed in so many different ways that what's being tested now, even before next gen, is light years different from what we remember as a bar exam. So I would say it is very important. There are a very, very limited number of sample questions produced by the Conference of Bar Examiners, and they have promised that they're going to offer some more. Whenever those things are available, I think it is really important. I think one thing that clinical faculty can do is to look at that content. And I'm not in any way suggesting to interfere with your academic freedom or to change how you teach or what you teach based on that. But I think kind of just digging in there and looking at the questions, at least you would know, I'm still going to do this. This is an important skill. We're going to do client intake. And just by the way, here's what client intake looks like to the bar exam. This is what they think, they're testing. I think just that information, that knowledge, that familiarity with the next gen format, and that would already help you. That would inform, what you're teaching and what you're sharing. And that's going to be very valuable because those students are listening to you and they value that. And it just reinforces what they're going to hear later from their academic support faculty and from in their bar prep courses.
Yeah, I think that's really helpful. I know in prepping for this conversation, right, even just looking back at the, docket design that I've had, and as I think about the, preparing for the next semester, right, it's so obvious that there are ways that if I just named what I was doing, right, it would help students just be able to transfer that to a different type of lawyering skill, right, and taking an exam. And I will definitely, right, take out my syllabus, right in the margins. Okay, this is how NCBE is naming this. This is not the words I was necessarily using, but okay, got it. I can use some of those, word choices at the same time when they do have more than one practice file, right? I will, be able to advocate and think about what else should go into it and how do I create a perhaps uniform experience on the client letter drafting exercise that I do that, can transfer over. But right now, I appreciated hearing you say there's limited information and also an opportunity to think about what we already do and not have the tail wag the dog in that. I find you so collaborative every time I've had the pleasure of talking with you. Do you have any recommendations on how other faculty, like how we can collaborate and, sort of transfer this relationship, right, across to every law school where there are people in our positions working in clinics, focusing on academic success with students? Any tips on sort of crossing divides that shouldn't exist but do?
I think the fact that you've asked that question, I think the recognition that it's an important thing to do and the willingness to do it is the first step. Collaborations are crucial. I say we, speaking for, not that I am authorized to speak for academic support faculty, but we're allies, and I would even bring in the legal writing faculty. We are allies. We're allies in label. We're generally allies in status. And most importantly, though, we're allies in supporting our students. Our ultimate goal, our pure and sole objective is making sure that these graduates are ready to practice law, making sure that these students can successfully start and finish, their law school educations. So seeing these similarities is absolute reason to step out of our silos and have these cross conversations, whether it's just lunch or even if it's, hey, today, here's what we're going to do today. Our clinical, our content is going to be about, the client intake process or the organizing the file or whatever the topic is. Hey, academic support faculty colleague, do you have 10 minutes? Can you come in and just simply address this topic in the context that it's tested on the bar exam? What do you have to say about that? That's an opportunity. But the collaboration isn't just limited to teaching, to classroom opportunities. It could just even be, hey, you know what? I don't do anything quote unquote bar related in my particular field or my particular clinic, but all my students are third years. Can you deliver in person via Zoom 30-minute tips on preparing for the bar exam, Q&A? Can you make yourself available for special office hours for these people? There are no limits to the ways that we can work together with the same goal. And I think, of course, students are always first, but we're co-first. Like students may be 1A, but we're 1B. None of us should relegate ourselves, because when we're vocal and active in our fields, what we are doing is we are being role models for those students. So we've got to advocate for ourselves as well. And so that whole thing, my running theme is that having that seat at the table, being vocal, finding spaces to have these conversations, that's important. And I think when we step out, when and if we step out of the silos and realize, wow, the goals and the struggles of academic support look a whole lot like the goals and struggles of clinical faculty, for recognition, for status, for acknowledgement, for legitimacy. I just think bigger picture in our objectives, we stand a much greater chance of moving the needle in the direction that it should have been going in the first place.
Yeah. Speaking of perhaps moving some needles, to take a step back from next gen for a minute, what's your take on the need for a bar exam itself, right? In terms of transitioning from when, students, right? I get them in a practice setting and in non-practice setting in other courses, right? To when they actually practice without a faculty member or supervisor right over their head. Like, is the bar exam still relevant or the right way to go?
Wow. So, I'll answer this question this way. And I've answered it the same anytime I've been asked that, but somehow, no matter what I say or what I write, I am, deemed a bar abolitionist. And not necessarily, I've never, carried a torch that says, get rid of it. But if we're going to have it, I insist that we tell the truth. If we call this exam a test of minimal competence to practice law, then it needs to be that. So, I have no opposition to having a bar exam, but if we're using the bar exam as the gateway into practice and a measure of competency, then we, all of us, every person with a law license needs to be committed to ensuring that it freaking really is a test that measures that. And unless it or until it does that, then it serves no purpose other than gatekeeping. And as we know with gatekeeping, because it is important to have standards for entry into the profession, but those standards cannot intentionally or unintentionally keep out folks who otherwise need to be in.
Yeah. Is there anything that, I know that there have been some clinicians who have been very active in some of the fights for alternative models of gatekeeping, since we as a profession have decided we're gatekeeping. Is there, for those that are going to watch the recording or on the Zoom who haven't been a part of those campaigns, are there any suggestions that you might have for ways to be better allies in sort of bar exam reform?
I would just simply say tell the truth, and it means you don't have to pick up a megaphone and blast it the way I try to, but really we just have to tell the truth. We can't use the phrase minimal competence. If the bar exam is the sole measure to entry into the profession, we just can't accept that equivocation. So it's really, really important to me that we be honest about it. And I would say also too, despite the bad taste in some people's mouths about the bar exam from their experience or what it's doing or what it's not doing, I think it's also important to kind of pay attention and not just automatically, close our ears when we hear this conversation. Pay attention to the alternatives that are being proposed and being developed in different jurisdictions. So again, whether or not you take on a reform platform, I really do think it's important to understand what options are there and to see the potential to make it better before we reach the point where there's one entity in control of bar examination in all jurisdictions and our input is no longer required, welcome, or even something that we could even give.
One more question for me before I open it up to others as well. Is there anything else on the licensing or bar exam sort of movement that's on the horizon that you want to make sure is on our radar screens as well, right? Because already, right, there's been a whole lot of stuff for people who might not have been in the weeds, right, in the various campaigns. So is there anything else you want to just make sure that this community writ large is aware of?
So absolutely, and that's a wonderful question. I would say, and I don't know, from where the people who join this or who will watch it later are, but watch states. Nevada has a wonderful, wonderful proposal underway where it appears, are deciding, to not adopt. I don't know if that a formal decision has been made, but in light of NCBE's announcement that if you don't take our new next gen exam, you can't use any part of our exam. They have made wonderful headway in designing their own exam that other states can adopt. And they've incorporated the flexibility of administering parts of this exam to students while they're in law school, when this information is fresh in their recollections. They have considered being transparent and providing, outlines of the scope of the content, like real outlines with real information that examinees could use to remove the necessity of paying thousands of dollars for a bar prep course, which has made actual bar prep cost prohibitive for a number of students, and it accounts for a lot of the racial disparity in bar passage. So I would just say, take a look at just some, if not one, of the resources available. Nevada stands out. Utah is developing a program that is an exam that's kind of, I believe, like performance test oriented, that would be available for other states to follow and use. So there are ways to maintain score portability that don't have to be sourced by the NCBE. And the NCBE, I'm sure, will continue to make a wonderful product. But what's on the horizon, take a look at some of these things. Ask your academic support people if you're not sure. Anyone can email me at any time, and I'm happy to share, a summary of what's going on. Washington and Oregon have already, their Supreme Courts have already, approved the development of both curricular non-bar exam pathways to a law license and clinical pathways to getting a law license, which is something that clinicians should be very concerned with. And then other states, Minnesota and California and others included, their Supreme Courts and their boards of bar examiners have said, we're willing to start to look into the potential of developing these curricular or clinical pathways. So yes, many jurisdictions are looking into these pathways, and they can still have a bar exam. These are just additional alternatives. And with the clinical pathways, that's got to be really, really important to this group. So that's what I want to share.
Yeah. Well, thank you. I have a ridiculous number of follow-up questions. However, I know there are some other people that are on the webinar. So at this point, if folks want to turn their screens on, we'll make it less sort of one-on-one and invite everyone back on screen and hopefully engage in more of an actual conversation. I am going to take the cue for anyone who has questions. You can either raise your hand or you can use the chat function. Go ahead, Bob. You can get us started.
I raised my hand electronically, but it didn't seem to work. So if I could share a little bit, I just came back yesterday from a conference put on by Access Lex about building bar skills, which was super informative, and I learned a whole lot. And I was talking about research that I and some other people had done on what's connected to bar success and what that might mean now. And I think we should be careful about thinking that clinics are going to carry a whole lot in next gen. I mean, I don't think there's any question that if you're in Oregon or Washington State and whatever comes next, I mean, clinics are going to be, you know, the secret sauce for students. But just think about what next gen is. So first of all, the good news is they've gone from 200 black letter law multiple choice questions to just 80, and some of them are not black letter law, but are really even multiple choice about what do you do next. They have these wonderful, I think, integrated questions where they give you a scenario, you got to write a short answer or ask a multiple choice question, and then they give you another layer of it and another layer of it, and then they have the MPT part, right? And good news is, I think for all schools, is that they all need to reconsider their damn requirements for bar subject courses, because we're going down to just 8, you know what I mean? And most of those everybody takes anyway because they're first year courses. But my worry about, you know, because, you know, some people were suggesting that, oh, now everybody should take a clinic, everybody should take a clinic, and I think everybody should take a clinic. But I don't know if it's because of next gen, because I think that clinics are so heterogeneous in what a student can get as experience that it's really hard for me to sit there and tell a student that take the clinic because of what now is coming with next gen, right? So yes, if you're going to get an interviewing and counseling or negotiation module in your clinic, or it's part of your everyday work, you bet, because that's now tested and you'll do well. But if you're in, you know, some Supreme Court appellate clinic, right, or if you're in some policy clinic writing white papers, I'm not sure that's advancing you at all. You know what I mean? And in fact, what really I think might now advance students are some more focused upper level simulation courses, you know, that really dig into the kinds of things they're getting at. I thought a really interesting thing that was shared by, at the very end of it, the NCBE brought in 3 people that have been doing their pilot testing, and, you know, they've been doing a lot of stuff and pilot grading. And they said, you know, a really interesting thing to them when they looked at these integrated questions, which are the ones that give you a fact pattern, and you got to think about it a lot, and then go to the next part, the next part, the next part. They said that so many students did poorly on that because of critical reading skills that they lacked, that they weren't really, you know, looking really closely at what was being asked and all the rest, you know. So I guess my sort of only thing is I think we need to be careful beyond being brought in to be the saviors in the building. We also, I think, need to be careful about overselling what a clinical experience can do for next year. I think we should still sell correctly, not oversell what it can do for the practice of law. But I'm just a little worried about the academic success people and the you know, the bar prep people thinking that I don't think the NCB's done what they said this was about, right? Because they said that this exam was about building on the successes of clinical legal education. And I think that's maybe about that much, but not enough, I think, to pound on the table and tell every student that if you want to pass next gen, enroll. So anyway, I didn't want to sermonize, but I just thought I had you know, sat there for a day and a half, and I really learned a lot, but also heard some people say some things that were a little troubling to me.
Well, I think, Marcy, can I respond to that comment? So I think, so first of all, thank you, Bob. And I don't disagree with one thing, that you've said. I think, and you said, we should be cautious about kind of overselling, the clinic or the value of taking clinic for purpose of next gen. I fully agree with that too. But I don't think that it's the case that either clinical faculty are selling, quote unquote, selling clinic for that purpose. But I also hope you don't think that academic support faculty or bar prep faculty are doing that either. I think, again, it's one of those presumptions, and I call it invisible labor, but could have any other name. It's one of those things of, well, if this exam is going to test skills or it's supposed to do that, oh, then we need to get some adjuncts to cover this, or, we'll just have more clinics. Let me just get some, no, that's not the solution. I would think that for clinical faculty, again, this is an opportunity for, and you all come in different sizes, different formats, different statuses, but it's an opportunity for different levels of quote unquote legitimacy within the institution. Like, I don't necessarily care why the students are coming, let them come, because no matter what, they're going to leave better than when they came in. And yeah, we don't purport to get them ready for the bar exam, but I think that's the important point. And I think that's why I, in this conversation, tried to focus on the opportunities for us as professionals, because either we can say, well, if all these folks are taking clinics with the purpose of helping them be ready for next gen, which is not what we advertise, let's assert some attempted pressure to then make next gen actually capture that, which is going to be a challenge, because there's such we've got policy legislative clinics versus litigation. It would be hard to do that, or to just simply say it's time for folks to recognize these are skills that folks need in entering practice. So, recognize our value independent of this exam. But anyway, I just wanted to add to that. I don't disagree with one thing that you've said, but I certainly hope it's not the case that there's a perception that at least folks in academic support area are saying clinics are supposed to be the saviors. And if law school leadership, if anyone, they should be quickly disabused of that notion, if any of them have it, because again, that is a tax and a burden that no one should bear. In fact, bar prep faculty right now don't carry the burden of making sure students pass the bar, but I understand that, those perceptions. So I just wanted to acknowledge, what you said.
If I can just say one other thing, I don't want to take anybody's time. The ABA has a proposal out, I think their comment period is ended, that requires every law school course that has sections where the faculty that teach that are supposed to get together and agree on common outcomes that will be, aimed for or taught across sections. If I were still, I don't have my Associate Dean of Clinical Education hat on these days. I sort of walk back from that. If I still have that hat on, I think at the very least, if I'm a clinical teacher, I'm going to have one of my my monthly brown bags with my clinical faculty, where we really look hard at next gen and ask ourselves around the room, what are we doing or not doing, and maybe tweak a few things, you know what I'm saying? So that at least we feel a little better, I would think, at least, about where there's an opportunity to help a student on what I think are legitimate skills, whether you're teaching it or not. Next gen is surely now testing some more legitimate skills to make sure that my people know about it and think a little bit about how they're doing things, and is there a way for them to think a little more about what the students are doing vis-a-vis where they're going later. But that's just my take.
I agree. I agree. With that importance, and whether or not the ABA Council goes forward or is successful with that is a completely different consideration. But yeah, I just cannot imagine any curricular decisions being made at any law school, no matter how that school is situated, without the input of clinical faculty. It's just unwise, but sadly it happens. It happens. I could probably take a survey and get a list of schools with curriculum committees that have zero clinical faculty members, on them. So again, I'm just nodding to everything you're saying.
Jocelyn. And also everyone is welcome to stay on camera if they would like for this part of the conversation. And if you have a question that you'd rather not be attributed to you, feel free to DM it to me and I'd be happy to ask it on your behalf. So, Jocelyn.
Yes, thank you. Sorry, I was struggling to find the unmute button. First, thank you so much, Marsha, for all you've shared. I definitely learned a lot through your conversation with Marcy, and I'm walking away with takeaways from it. I have a more pointed question as, a co-director of an immigration clinic where the bar it does have relevance in the sense of the performance evaluation aspects of it, right? But in terms of subject matter expertise, a lot of my students have asked me the question, like, I don't understand, why do I have to take this bar exam when it doesn't even test my competency in what I'm trying to do? And I similarly felt that frustration when I was taking the California bar and learning about corporations, which I had zero interest of ever practicing. I very much knew I was going to stay in this field. Um, and so obviously I knew it was a hurdle I had to pass to do what I had to do and wanted to do. And so that's how I got through it. But I feel less justified as a faculty member now telling my students that narrative. Like, I'm sorry, this is how it is, and you just have to pass the hurdle. I know this does not do anything in regards to your subject matter expertise, but this is just the way things are. And so I would love to learn a little bit more from you in terms of any suggestions, recommendations on how to respond to that and how to make it feel less more of like, this is a hazing ritual that we have to enter the academy. And once you're there, you can do as you wish.
Well, I would love to respond and say, here's some great insight on what you just asked, but your question is very honest, and it's just a reality. And right now, the bar exams that we have right now in their current format, they are that. I mean, a person would not be wrong to call them hazing rituals, because that's what they are. And so much of the support for the bar exam is just, well, it's just this thing that you have to do without us taking the time to think and reinvest in the future lawyers in our profession. But I would say, and this is certainly not a plug because I'm not in the state, but the Nevada plan is, again, they're using bar examination and exam, but one component of the requirement is to also have some clinical experience, and no one could be licensed under that program without it. That way, whatever the clinic is, and so that is something that Next Gen just simply missed the boat on. But imagine that, because what clinical faculty offer is important to licensure, and it should be, but there shouldn't be some requirement of, oh, we've got to prepare people for the bar exam, or they're going to take our class and bar examiners are going to come into our clinics and assess, what we do. Your faculty, your licensed attorneys, well, I mean, we can be assessed for, quality, but not for bar examination. But looking at models like that, this really and truly is a wonderful opportunity to see what's available, because I agree. And I don't think it matters what form of clinical education you get, but I think that is a crucial and important part of, being declared ready to practice law. So there is the potential for a program that has a bar exam, that tests stuff that we have no control over, and that requires clinical education either during law school or in the period of time that normally would be spent during bar prep. And I think that's a beautiful model, and I think people should be familiar with it. And you didn't ask that, but I would be remiss if I didn't mention this while I have this wonderful platform. Every clinician, every person wanting to become a clinician, every dean, every law school, everyone should read Joan Howarth's book, Shaping the Bar. Because one of the things that she proposes, she talks about that no one in any jurisdiction ever should be licensed without having some clinical experience. And whenever people talk about getting rid of the bar exam, they say, well, would you have a pilot that didn't take an exam? Would you have a medical doctor that, those are always the go-tos, but no one becomes a pilot or a licensed physician unless or until they go through a clinical residency and they demonstrate that they can do that. That's a difference. Lawyers can represent a client who is indigent just because they passed a test. So here, Joan Howarth's book talks in detail about the essential nature of clinics without putting any additional pressure on clinical faculty to determine or to prove to someone else, that their assessments are okay. But so anyway, I highly recommend that book. It's such an easy read, and it really is wonderful and reaffirming of the great work that you all already are doing.
Thank you. I really appreciate the book recommendation, and I've already searched it. So
Before we see if anyone else has questions, Marsha, I was hoping you could tell us how to alleviate, or your thoughts on how to alleviate the concerns that the sort of first crop of next gen bar takers are going to have, right? With all of the uncertainty of like, there's such limited information for them now. They can't get the advice and support. I see it in clinics. I see it from my clinic alums, how they support each other through the process, right? Which is true both in clinic and for the bar exam, right? In terms of the community they build for themselves, when and how they reach out to faculty for support. Clinicians tend to know our students more intensely and closely, and so we are hand in hand often in terms of teaching them the sort of self-care for something like a bar exam. And so many clinicians are incorporating more self-care and mindfulness training and other things into their clinic dockets. And so I wonder if you have any sort of initial thoughts on, how to support the first, second, third set of students that we might think about as we sort of design how to help students prepare for their first, second, third testifying or testimony or litigation trial or other things like that.
Yeah, so that is a question that is being asked throughout the academic support, community. And it's one we all want to be able to answer, because that in part, that's a big part of our roles. And so, my response to that, I will just connect that to something I said earlier, is I think step one would just be to go to NCB's website. And I think someone may have posted a link to NextGen, and just take a look at the sample, the actual, because we can hear this description of it, but just take a look at some of the question sets. So at least you're somewhat familiar with what the NCB has shared as insights into next gen content. Because I think if nothing else, just knowing that, having seen what you've seen yourselves, will kind of put you in a better position to respond to students and help guide them. For example, you could say, yeah, when I took the bar exam, I did this. And, these questions here, it looks like what I did or what I'm familiar with, but just, there's an extra step, or now this one question is connected to another one. So I think just seeing it yourself would give you some additional assurance, and to say, well, based on what I saw, here's one thing that I see that's different. Here's some things that I'm familiar with that seem the same. The other thing I would say is, this is a time to go, you know what, I want to answer that question, just like how you've asked me, reach out to the academic support faculty at your school, because as you reach 2026, we hopefully will have received more information from NCBE. And since academic support is generally at the forefront of this, they're going to have more information then in the future than I have right now to help you respond to those questions for students and to support them. And then ultimately, it is a standardized and curved exam. I'm not willing right now to offer a prediction as to what scores are going to be in the jurisdictions that have, volunteered to be the guinea pigs for the first administration of it. But I will say this, NCBE is certainly committed to the success of this product, and NCBE wants the national adoption of this product without any exception. That is what they want, and they're not shy about saying that. So to that extent, I would say they're very invested in making it successful. I can't imagine a scenario wherein, because they do the scaling. I'm not suggesting anything improper, but I can't imagine any scenario whereby the first administration of this exam, even if the bar pass results are lower or there's a dip, because that's often what happens when we see a change in exam, I can't imagine a scenario where the outcome is one that students overwhelmingly were unprepared or don't pass the bar exam, because just factually, as a business matter, that's going to affect the success or other states' interest in that exam. So I don't necessarily know that I would share that with students, but for faculty who have a concern about assuring their students and helping them, it would not be in the interest of the success of this exam to have the results of the first administration of it to be catastrophic for students. And that may sound cynical, but that's practical and it's factual. So there are going to be uncertainty. So I think that's something that should comfort you in terms of, are my students going to be, just killed by this exam? I would be shocked if that's the case.
Yeah, that's really a helpful reminder, as well as the reminder that it's a product that is being sold to lots of jurisdictions, to lots of stakeholders. You know, when the stuff was released and there was only sort of one file for the skills component piece of it, I was like, give me more, right? Give me more. So I had some of that anxiety, right, of what I imagine many of my students will have of just wanting to know more, right? I used to run a clinic that did a lot of unemployment insurance hearings, right? Limited amount of law that we were applying to facts. I could see a wonderful parallel, right, to the potential file that NCBE is creating, but without knowing a little bit more, right? I'm just speculating and guessing. And if my anxiety goes up, then I can imagine, right, the students that are actually taking the exam, what it feels like for them. And so stay tuned, I guess, for future iterations and future conversations. Before we wrap up, I want to give you the opportunity to say any sort of closing remarks or thoughts. You know, I know I always learn from our conversations. I also know this won't be the last one that you have with me or with other members of the academy that teach in clinics. And I'm so grateful for your willingness to, I said it before, but to always be, you know, collaborative and open and honest and call to task the powers that be when they need to be called to task, and also to have grace and thoughtfulness and cheer, right? When there is time to have grace and thoughtfulness of cheer when people are being listened to or being heard in this process, whether it's a different type of alternative, whether it is, you know, whatever model questions come out next. And so any sort of final remarks for this part of what I know will be an ongoing conversation?
Well, I just want to again just thank you. It really, really is an honor to have this invitation, and so many of my close friends and individuals that I've met, you know, who also offer clinical instruction are folks that I just respect and admire greatly. And so I guess my final note is just the fact of the people who did tune into this to hear this. You're doing it, you know, because you're concerned. There's something new, you know, there's some new queue, something new in the queue that we've got to all prepare for and adjust to. And this has happened each time the bar exam has changed. It's just affected the faculty whose part has changed. When they took secure transactions off the bar exam, when they added this, when they added performance tests, legal writing professors, like, what do we need to do? What do we need to do? You know, this time they're saying skills and practice. So, you know, obviously, you know, caring and compassionate clinical faculty are like, well, what do we need to do? I just say at some point, regardless of your position, we really have to be very introspective and just say, wow, how much does this bar exam drive legal education and curriculum? Even though we say, I don't care about that, you know, the bar exam is different, it's not like practice, you know, we're instructing people within our expertise and skills, and yet and still we question, how do we need to do this differently? What do we need to do? What do you know, what if we're going to make any changes? Let's look at the bar exam and make sure that we're all in agreement about these things. And that just simply, if that is going to continue to be the case, it's because we allow it. You know, why isn't it the case that faculty get together and say, these things we think are important, let's tell the bar examiner? So like, we've just accepted this, and really, you know, if we uniformly as legal educators continue to accept that, today it's next gen, 5 years from now, 10, 20, you know, we'll be doing this again. And so at some point, you know, we can really decide whether or not we're going to drive legal education, or let a bar exam that is written by an outside entity is going to dictate to us what we have to teach to educate our students. And that's just a really important question I think everyone has to reckon with, regardless of your stance or your answer to that question, because that's precisely what's happening.
That's really helpful, and I think very comforting for me to hear as I'm also thinking about, like, how can I redesign my course or incorporate a lot of what I learned today. But thank you so much, Marsha, for gracing us with your wisdom and your perspective. It was very much a educational and interesting and thought-provoking conversation. So thank you, and thank you everyone for joining us for our last episode of the season of Conversations with Clinicians. Please stay tuned for an announcement for our next season in the fall, and have a lovely evening.